on adequate housing from 2014 until 2020, and she is now the global director of The Shift, and that's the global movement to secure the right to housing. And in this talk, if I'm correct, she's going to talk about the legality of evictions under domestic law, and she will look at them from an international human rights law perspective, looking whether these domestic law evictions are legal or maybe even illegal. Leilani, the floor is yours, and thank you.
Thank you so much, Michelle. And can I just verify that I was going to speak maybe for 20 minutes? Is that what you were expecting?
Yeah, that's perfect. We are very free in the format, and so it's completely up to you. And then we have more time for a discussion, so that's great.
Yeah, I think this topic lends itself to discussion, in my opinion. Again, apologies everyone for being a little bit late. I'm very happy to be here, and I think this is actually such an important discussion. The tension and complementarity between domestic law as it applies to evictions and international human rights law. And I say tension because most domestic law as it pertains to evictions doesn't consider international law. In other words, it's drafted by people who often know nothing about international human rights law. That doesn't mean they don't care about tenants. It doesn't mean that they think evictions are a great thing. That's why we have domestic law that prohibits evictions or tries to regulate evictions. But it's pretty rare in my experience where you have domestic legislators who are actually poring through international law to see what it says and then trying to reflect that back in domestic law. I hope that's changing now because we're trying to popularize, many of us and probably many of you on this call, trying to popularize international human rights law and the standards and trying to get that reflected in domestic law. But that's not always the case. So I thought I would start by just explaining security of tenure under international human rights law and what regulations exist, what international human rights law says. So, first of all, legal security of tenure is considered a cornerstone of the human right to housing. And it's obvious to most of us, I think, why security of tenure is so fundamental to the human right to housing. Because without security of tenure, legal security of tenure, the implications are very grave. It can result in the forced removal of people from their homes and lands, forcing people into homelessness. And we know that homelessness is directly related to one's ability to survive, to the right to life. And there is nothing more grave or more serious under international human rights law than jeopardizing one's security of the person and one's right to life. And so that's actually why the right to housing itself is considered so fundamental in international human rights law, because it is so directly related to the right to life. If there's a pillar in civil and political rights, it's the right to life. And if there's a pillar in social and economic rights, it's the right to housing. And security of tenure is central to that. So we're in very serious terrain in international law when we're talking about legal security of tenure. The United Nations system has come up, with a definition of legal security of tenure. And it comes in General Comment number 4, written by the Committee on Economic, Social, and Cultural Rights. I think it was written in the 80s. I can't remember the date at the moment, but it was in the late 80s, so pretty old. It has stood the test of time. And we have Philip Alston, Professor Philip Alston, to thank for that. He was the main drafter of General Comment number 4. And he is a brilliant human rights advocate and thinker and academic, and managed to come up with this definition of what the right to adequate housing means through General Comment 4. And I tell you, I go back to it weekly, and it stands the test of time. Here we are in 2022. So I'll just read it to you. I'm sorry, I don't have a slide. I would normally put up a slide, but I didn't do PowerPoint for this because I thought it would just be conversational. But I'll read it to you. It says, tenure takes a variety of forms, including rental, public and private accommodation, cooperative housing, lease, owner occupation, emergency housing, and informal settlements, including occupation of land or property. Notwithstanding the type of tenure, all persons should possess a degree of security of tenure, which guarantees legal protection against forced eviction, harassment, and other threats. States parties, that's the governments that have ratified international law, should consequently take immediate measures aimed at conferring legal security of tenure upon those persons and households currently lacking such protection, in genuine consultation with affected persons and groups. So in other words, all governments and all orders of government, so whether you're talking municipal government or you're talking national level government, or if you live in a federal, state, provincial, or state governments, have an immediate obligation to ensure that all persons possess a degree of security of tenure that guarantees legal protection against forced eviction, harassment, and other threats. And then they also have an obligation to take progressive steps, progressive measures to strengthen security of tenure for all persons using land or housing for their basic housing needs and who currently lack such security. So you see immediately one of the difficulties that we run into, particularly in fully developed countries that have developed landlord-tenant legislation, because where there is landlord-tenant legislation, it often does confer security of tenure and only allows, in apartments or in home ownership, and only allows eviction under very certain circumstances. And so those would not be forced evictions. So then you might say, well, what's the applicability of international law in a context like the Netherlands, for example, where you do have, where most people, or I would say the bulk, have some kind of legal security of tenure if you're in an apartment or in a home. So what's the application of international law? And there's a few applications, but one thing I do want to say that comes in a different general comment, also written by Philip Alston, general comment number 7, that pertains very much to forced evictions. It says that eviction should, regardless of whether it's forced or not forced, should never lead to homelessness. And that would be a prima facie violation of the right to housing, an eviction into homelessness. So I just want to circle back and explain what a forced eviction is. It's the involuntary removal of people from their homes or lands. It's that simple. And eviction into homelessness is obvious. I don't think I need to explain that. It's where an eviction renders a family or an individual homeless. So in the context of developed countries, and I think in the Netherlands, we see this where people, let's say, start accruing arrears. Arrears is considered, that's, when you're unable to pay your rent for a couple months. Maybe there's a global pandemic and you've lost your job and you suddenly are unable to pay your rent. If there isn't an eviction moratorium, if there's no rent forgiveness, and you fall into arrears, then a landlord normally has, in most developed country jurisdictions, has the ability to evict you legally. And so then you say, well, what does international law interact with this? What does international law have to say about this? Well, it says that no one should be evicted into homelessness. Well, most landlords don't inquire whether their eviction is going to lead a family or an individual into homelessness. And so we're seeing across the world, especially in developed countries, many evictions leading to homelessness, which would be legal in that country and illegal under international human rights law. I think in the Netherlands, you do have some provisions around this, where if you're living in public housing, I'm not sure if it's across the Netherlands or if it's just in certain cities, but where if you're experiencing trouble paying your rent, you should make this known to if you're living in public housing, you should make this known to the housing provider, and the government should then be equipped to help you pay your arrears and make sure that you don't lose your tenure. I don't know that that applies in private rental tenancies in Netherlands. So you all can inform me after I finish. Oh, and I see someone said, yes, it does. I don't know where the chat is exactly, but I got a pop-up. So there we go. And so that would be a human rights compliant and very human rights proactive legislative measure or policy measure to ensure that people are not falling into homelessness simply because of arrears. And the reason that that's so important is obvious, right? We don't want people to fall into homelessness because of what I've already said. The direct connection. We know people who live in homelessness have much higher rates of mortality and morbidity. They fall into they contract preventable diseases, and they have much shorter life expectancy. And so that's obviously contrary to human rights. And so I would say the Netherlands, from what I know, and there are people with far more expertise about Europe on this call than me, to me, those provisions are unusual. I've heard of something similar in the UK, in a small city in the UK, in Spain, in some jurisdictions, they have legislation, I don't know how effective it is, whereby you should not be evicted into homelessness, and an adjudicator who's adjudicating a claim, an eviction hearing, would ask the parties, is there a likelihood of homelessness? And where there is, the tenant is, I believe, connected to a social worker, and there's supposed to be some kind of resolution so the person doesn't fall into homelessness. I don't know that that's actually working effectively, but I understand that there is such a policy. Those sorts of policies are obviously human rights compliant because we should be trying to avoid homelessness. Where we get into more tricky waters, where landlords do things that are quite legal, but in domestic legislation, but would be contrary to human rights law, is around things like, we use this term in North America, renovictions, or where landlords are buying buildings or units and upgrading those units and making them unaffordable and making it difficult for that tenant to continue to live there. There's a variety of activities that happen in that regard. Landlords often will create what we might call a hostile environment in a building. At the Shift, my organization, we hear from tenants all over the world who are living in buildings that are what we call financialized buildings, that, in other words, owned by a big financial actor, whether it's a pension fund or a private equity firm or just a big real estate corporation, a public company often, where the company has decided, well, this building's kind of old, we're going to upgrade it, and they know that in upgrading it, they can then apply to raise rents above guidelines. And this is all done, and these actors will say, we're not doing anything illegal here. We're allowed to do this. We're, in fact, making this building more energy efficient, and we're making the building nicer. And it's all done quite legally. They apply for the above guideline rent increase, and they're granted that increase. Meanwhile, the tenant is sitting there, I cannot afford this unit anymore. And one of the other sort of central aspects of the right to housing is that housing, in order for housing to be adequate under international law, it has to be affordable. And affordability is based on household income, not based on what markets can bear. And so people are being forced out of their units. We've seen, big movements in Berlin, in Barcelona, and other cities across Europe, in Lisbon, where people are really trying to push back against the unaffordability of housing. But the unaffordability is happening in a very legal sense in the domestic legal context. And yet under international law, those would be what we might call constructive evictions. I would consider them to be forced evictions, and therefore contrary to international human rights law. In order for someone to be removed from their unit, legally under international human rights law, in order for it to move from a forced eviction to just an eviction, there's a whole process that would have to happen. And those processes never happen in the context of rent eviction. The process would have to involve, it really shouldn't involve the person ever having to leave, but if the process should involve meaningful consultation with the tenants before any construction or redevelopment is done on a unit or units. The tenant should be relocated if necessary to another unit that's proximate to where they're living. They should not have to pay any more rent for that relocation or any expenses for that relocation, and they must be allowed to return to their unit or a similar unit of similar size and a similar location at the similar rent. And of course, that never happens. That is what's required under. I'm jumping a bit about the process, but that's what should be happening under international human rights law, and very rarely is that required under domestic law. Another area, and I'm going to wrap up my comments with this, that we don't talk about a lot. Because, well, I'll explain the situation why we don't talk about it so much, but even home ownership and foreclosure on a home, that all happened. So let's think back to the global financial crisis, because it's so relevant in the European context, especially in places like Italy and Portugal and Spain. But even the Netherlands, I'm owning my home, and I can't make my mortgage payments, and the bank forecloses on my home. That's a totally legal structure. It is the way the mortgage system works in country after country. You get a mortgage, you pay that mortgage. If you don't pay that mortgage, the bank forecloses. And in some jurisdictions like Spain, foreclosure is very draconian. You still have to pay the debt even after you've been evicted from the home and you're living elsewhere. That debt of the mortgage is carried with you. It's very draconian, really causing so much strife. In other places, the debt is forgiven, the home is resold, and etc. But the person is often left in homelessness or left in a very precarious situation. That is all legal in the domestic context. Under international human rights law, it's not so legal. First of all, because security of tenure is so important, and as I read to you, everyone must have some degree of legal security of tenure. But also, in many cases, as we saw in the global financial crisis, people were left homeless as a result. They were penniless and left homeless. And disastrous. Suicide rates went up The United States, there are figures out of the United States on suicide rates. Greece is another country where this is very relevant, where the suicide rates also went up because of this. So international law would treat that quite differently than domestic law. This was just, and maybe regional law. I'm sorry, I don't know the European Union system well enough to know what was allowed under European law and how much of this came under EU law. But it's the reason we don't talk about this so much is normally homeowners and international law, homeowners are considered the cream. They're not so often vulnerable populations. But during a crisis like the global financial crisis or a global pandemic, homeowners suddenly become very vulnerable populations. And obviously the ambit of human rights extends to everyone. And it normally attaches most seriously to vulnerable populations. I'm going to stop there because I think I've thrown a lot out, and hopefully it was coherent and will generate some conversation and questions, debates, etc. I haven't been following the chat. I'm still looking for it. There, I found it finally. I don't know if I should look at the chat, or maybe Michelle or someone will convey what's going on in the chat.
Yes, definitely. Many thanks for your very interesting, but I think mostly very triggering presentation. I think it fuels enough discussion, which can start now. Indeed, there has been some things going on in the chat, especially Ana Fernandez. You posted a very interesting comment and question. Maybe you could open up your mic and say the question.
Hi, do you hear me?
Yeah.
Do you hear me? Okay, happy to do so. Leilani, I'm actually speaking from Barcelona. It's a pleasure always to listen. And my question here, because I'm always trying to enhance this in the internal debate, you said some evictions can be legal in the domestic law, even though they are illegal according to international law. But in a legal system that considers international treaties signed by their governments, by their states, part of their legal system, it means that they integrate their domestic law, then it's illegal in any case, even if the laws in the countries contradict the international law. I'm going to read it as I put it in the chat. In Spain, international law, according to the what we call the hierarchy of importance of law, goes under constitution, but above legal laws, internal laws or domestic law, which means that if a law would somehow contradict an international treaty, then the law has to be considered not applicable. I'm not sure if I'm explaining myself right, but we should start saying that it's illegal in any case, even in domestic law.
Yeah. I think that's such a good point. And where you do live in jurisdictions where international law is domesticated, as we say, I think that's absolutely right. Many of us will live in jurisdictions, however, where it's not domesticated and where it's really only interpretive. So international law should be used to help interpret the application of domestic law. And so in those cases, I think what we end up saying is that it's sort of non-compliant with international law. But I agree with you, the more that we can emphasize that evictions or some evictions are illegal under international law, it's powerful and is certainly the way I view it. I will say in my own domestic advocacy, like right now, for example, I'm very engaged with some institutional actors who own many apartment buildings across Canada. And they say to me all the time, hey, everything we're doing is legal. We're just using the laws. We're allowed to renovate and get back our costs by raising rents. And that's all we're doing. And then I say to them, yes, but our laws have to be interpreted in keeping with international human rights law. And what you're doing is you're making these places unaffordable to your tenants. It's constructive eviction. Sometimes in fact, in some jurisdictions, what we're seeing is where it's possible to raise the rent on a unit that is empty. So let's say I'm a tenant. I decide I'm going to buy a home. I happen to have some savings, some mega savings. I'm going to buy a home. I'm going to vacate my unit. And then once the unit is empty, in some jurisdictions, a landlord can raise the rent to whatever they want. What we're finding is that many landlords are engaging in practices that encourage people to leave their units so that they can get an empty unit, make a little few changes, put up some nice drapes, curtains, and raise those rents. And so trying to use international law to address that scenario, very difficult. But I like your emphasis, Anna, by we should be consistent and persistent in saying, the world community came together and has agreed on this set of standards, and you're contravening it, even if domestic law allows you to do that.
Yes, even just a little reply. Even in when the judges, they decide sometimes disregarding international law, whereas it has hierarchically, it has an enhancement force that goes above the domestic law. Right. So I think we need to make in the international debate and our domestic debates a point on that even according to our legal systems, they are not deciding and they are not applying laws according to our legal system, our domestic legal system. So yes. It's not legal in any case. That's my point.
I agree with that. In fact, when I was rapporteur, I had that very conversation with the government of Spain to say, because where it's domesticated, that's very powerful, right? And they must use international law in domestic law. It should be one and the same. Yeah. I think there was a hand. I don't know, Michelle. If
yes, Michelle Vos, go ahead.
Thanks so much, Leilani, for this interesting talk. And the first comment I want to make, in a lot of documents you see there need to be legal protection against forced evictions. But I always find that a bit frustrating, because if you look at the definition of forced evictions, that's an eviction against someone's will, and there is no provision of or access to appropriate forms or legal protection or other protections. So basically, if you say you need to provide legal protection against forced evictions, you say you need to provide legal protections against evictions without legal protection. And that doesn't say that much, right? So I would frame it like this. Every eviction falls under international law. You need to provide legal protection against every eviction, even like the cases of mortgage arrears, which you just explained. And if they don't comply with the requirements, then it's a forced eviction and can be seen as illegal under international and maybe then also under national law, depending on the status of treaty. So that's more of a comment, but I want to explore the boundaries of these requirements a bit. So suppose in the Netherlands we have cases, even in a pandemic, where someone didn't pay his rent for 6 months, there was healthcare agencies going to the tenants, still they decided not to pay their rent, and in the end the court did a proportionality review and said, so this private landlord cannot take this longer, right? There are 6 months of arrears, and this person is going to be homeless. We're going to dissolve the lease, and this person is going to be homeless, right? So in the end we have in the Netherlands people ending up on the street. Do you consider that a forced eviction, so an eviction illegal under international law, or not?
I consider it to be under the domestic law of the Netherlands. It's a legal eviction that is contrary to international human rights law because it's resulted in homelessness.
Yeah.
So therefore would be illegal under international human rights law.
Yeah.
Yeah.
So okay, that's so. And even if we take like a year and help the tenant, but the tenant refuses him or herself to accept any help with finance, for example, and after a year it becomes homeless, do you still consider that to be a violation of international law?
Sorry,
is there any subjective?
Could be that the person just has money, is wealthy, but refuses to pay their rent.
Or and maybe that's even more extreme, but maybe they don't have any money, but they just don't want any financial support or assistance. They just say, so I'm not going to pay the rent.
I think under no circumstances is it acceptable to allow someone to be homeless. Yeah. And so we have to take every situation in its particularities. That person would need to understand that and would need to be worked with social workers, etc., to understand their circumstances, and that the result of them not paying any rent, even though they could afford even 30 euros a month or whatever, is homelessness. The thing is, these scenarios are so few. Like, how often does this happen? Like, it's so rare. So we don't make policy and law based on the few, but our interpretations of human rights law, international human rights law, have to be flexible so that they can apply in every circumstance, if you see what I mean. So though international human rights law or domestic law may not really be for that scenario, we have to figure out how to make the laws work in that scenario. But the bottom line for me, as an international human rights lawyer, is that homelessness is absolutely not acceptable. And it cannot be. And people say, well, some people choose to live on the streets. Well, I'm sorry, but I really believe that that's not true. I think that we as society can work with people to ensure that they are housed. And I've never met a homeless person who didn't want to be housed. No one, even the chronic homeless, and they say, oh, it's that what we offer people living in homelessness is just simply not what they want, or not what they can afford, or not how they can envision their lives. So we as society have to be so often we're saying to a homeless person, why don't you, if they're on their rough, why don't you go to a shelter? Well, shelters were not designed by homeless people for homeless people. Definitely not. The rules in shelters are awful often. Not all shelters. Shelters are starting to change their rules, but I mean, we shouldn't live in a. I don't think we should have shelters. Personally, everyone should be adequately housed. Shelters don't meet the definition of adequate housing, of course.
Yeah, so I agree with you, right? So if you look at the general comments and also the individual decisions in complaint procedures, the committee is absolutely clear that you should be rehoused after an eviction, right? Even if it's your own fault or whatever, right? That's the case. But for example, in the Netherlands now signed the optional protocol a few years ago to go to the committee, which is a good thing. But now they saw all the case law from Spain and Belgium, and there will be Italian cases. And now the Netherlands said we're never going to comply with these requirements because there are 30,000 tenants in public housing that are evicted each year, right? So, and we cannot provide them with any other housing, and that's the argument. It will give them an incentive not to pay their rent anymore because they will be rehoused. How do you see that, right? So, because that's basically a big loss of the human right or the right to housing movement in the Netherlands, because the government is not going to ratify it, and we cannot go to the committee. Yeah. So how do you see that?
Yeah. Well, this whole idea that people don't want to pay rent and that there would be incentives to not pay rent. Again, I've traveled the world. I've met tenants everywhere around the world. I've never met a tenant or a person living in an informal settlement or in a shelter who didn't want to pay their own way. Everyone is willing to pay. People want to pay within their means They want to have money at the end of the month to pay for food and clothing and medicines if necessary, and etc. So I think governments make up these things about tenants. So we're not, oh, it's going to be an incentive. If we ratify the OP, everyone, the optional protocol, people are going to read the decisions and see that they can't be evicted into homelessness, and so we can't evict them, and they're just, I just don't believe that. And another cornerstone of the right to housing, also not talked about, although I think I didn't write a report where I didn't mention it in my thematic reports, is this idea of meaningful consultation and participation. And so much of the bad stuff that happens around housing could be avoided if tenants and people living in homelessness were simply consulted. I shouldn't say simply consulted, because it's actually not that easy to do meaningful consultation. But meaningful consultation and the meaningful participation of rights holders is becoming a right unto itself. And we're starting to see in new constitutions, like the Kenyan Constitution, somewhat new. The Kenyan Constitution includes the right to participate as a human right. And I think that landlords and governments who are engaged in housing policy or finance policy need to start figuring out how to meaningfully engage tenants and people living in homelessness, because the answers to a lot of the problems in housing are right there. Tenants know, dwellers know how things could be solved. And rather than listening to who governments tend to listen to, which is housing providers and big finance. One of the things I keep asking governments to do in my work is to start leading in the area of housing. And that means not being led by finance, not being led by housing corporations, but rather for governments to lead. And in order for governments don't know what to do about housing, governments don't know. They have to talk to tenants and dwellers and their advocates. I see, I don't mean to cut off our discussion, Michelle, but I do see Maria Jose has weighed in, a good friend and colleague. Nice to see you. So I don't know, I can't now open the chat for some reason.
Yeah, she says, are we speaking about alternative accommodation or alternative housing?
Exactly. I mean, point well made, right? And we should be talking about alternative housing. I think that's your point, right? That we're often talking about alternative accommodation rather than alternative housing. But maybe you want to speak to it, Maria Jose?
Hi, Leilani. Nice seeing you again. It's been a while.
Yeah.
I mean, I think that's Spain's been mentioned a few times now. So I think one of the latest changes in the legislation was exactly about that, consulting or involving the social services before an eviction took place, and for the social services to provide alternative accommodation. I think it was alternative accommodation. So I think what they are actually doing in practice is offering, I think it's hostels, like places in hostels for people that are evicted, and that covers like the thing. Obviously, I mean, from the perspective of international human rights law, it's probably not the idea, but it's at least something, or we didn't have that before in the legislation. I don't know what you think, but I think I read somewhere that this thing about alternative accommodation, alternative housing, that should be subject to another general comment. I don't know where I read it, but do we have to do general comments every time that there's a concept that should be closely defined? I don't know, more, I don't know, just a question. What do you think?
Sorry, Leilani, before you answer the question of Maria, Too Bright needs to go, but she had a question. Sue, do you have 2 more minutes to ask the question? Or maybe she already left. I'm not sure.
Darn it.
She might already left.
Sorry,
Okay, sorry. Go ahead.
I didn't intend to jump the queue. I'm sorry.
No problem.
I wasn't aware there was someone else.
I forced you to jump the queue. My apologies. Oh, so she's gone. So and she didn't put the question in the chat, Michelle?
No, she didn't put the question in the chat. So go ahead. Sorry.
Okay. I should say, I mean, there's, in my own work, there's how I interpret and understand international human rights law. And then there's where I'm willing to go with governments in my advocacy. And just before this conversation, I was in conversation with my team about how slow and incremental change is. And so sometimes we have to settle for something that's maybe not fully compliant with international human rights law because it's better than whatever the alternative is. So that's sort of what Maria Jose's point is about accommodation. Like, when the pandemic struck, for example, and there were people living rough on the streets, and we knew that they would be very vulnerable to getting COVID. There were no vaccines at the time, you'll remember. And we knew that they were exceptionally vulnerable. And so many cities started housing them in motels or hotels. And this was considered quite a victory. And it is a victory because it's better in the face of a global pandemic to be living, or even outside of a global pandemic, to be living in a hotel where you can close your door, lock that door, you have your own shower, you can get into bed, and, it's much better than living rough. But is that compliant with international human rights law? Absolutely not. And homelessness is it's a prima facie violation of the right to housing, and states have to do everything they can using all of the resources available to them to address homelessness on an urgent and priority basis. And so hotel would be a step maybe toward. I don't even believe in that. I mean, I think that I don't believe in a staged progression toward housing. People who are homeless should be properly housed in adequate housing and provided the supports that they might need to make a good go of that. I'm not one who likes to see international human rights law defining every little term. The way in which these terms should be understood is through practice, and we'll and through litigation at the domestic level. That's how we learn what law means, and that's how law can be like they say a growing tree, and there's that understanding of constitutions as sort of trees that are constantly growing, and that's how I like to view international human rights laws, as well as domestic law. Obviously, I'm very different than the Supreme Court of the United States of America, that who are originalists. I'm not an originalist. I think that law has to change in keeping with the way societies change. And so, for example, when we're seeing these new kinds of evictions that are technically legal, I think international human rights law can be very responsive in showing that, in fact, these domestically legal evictions are actually illegal under international human rights law. I think it's very powerful and very important. And then we will get laws changed, and jurisdictions will start seeing that their laws around eviction and what's acceptable need to change as the housing actors manipulate those laws, is what I say. So I'll give you an example that I think is kind of cool. It's a Canadian example. Evictions is a big phenomenon here. So renovating places and redevelopment of. So a property owner will let a property fall into disrepair, so much so that it can no longer stand. That housing has to be demolished and new buildings have to go up. They do that so that they can move low-income people out and move higher income people in. And what we're seeing is in some jurisdictions, and that's all done totally legally, and we consider it forced eviction, none of the requirements are adhered to under international human rights law. Meaningful consultation, relocation, and the right to return. None of that is adhered to. What we're seeing is some jurisdictions, some cities, Burnaby, British Columbia, for example, are adopting bylaws that revisit what should be legal in those contexts and creating new laws that are specific to those scenarios. And those laws these new laws are using international law and standards to inform those laws. So that's how I like to see the movement. That's in fact how international human rights law should work. It should be taken by people at the domestic level and put into domestic law, even if international law is not domesticated itself. Sorry, I hope that made sense.
Definitely. There are some questions in the chat, and we have a few more minutes left. Emma, you posted a question in the chat. Maybe you could open up your mic and ask it, if you want.
Yeah.
Oh, I think your internet connection is not good enough. Could that be the case? My mic will not work on my internet. Okay, then we just read out the question that she already posted in the chat. She said, I'm curious for the states who have not domesticated international law, but rather use it as an interpretative tool. Would this need to be addressed by the legislator, or would there be room for change on the judiciary level? In other words, when a judge is applying the law to any given eviction, would this be an overstretch of the judiciary or in line with the interpretive value of international law, in your view? Could you see this as a bridge towards mending the tension while legislative change is sought?
So, legislators should be using international human rights law when they're developing legislation or when they're interpreting it or applying it as legislators. That's for sure. And that's, I wrote a report on rights-based housing strategies. I think every state and all orders of government should adopt rights-based housing strategies. And the way to do that would be to look at what international human rights law requires and incorporate that into a housing strategy. And so yes, but also too should the judiciary be using international human rights law as they are confronted with cases where it's relevant, where the right to housing is relevant. Absolutely. And in some jurisdictions, you will have cases where that point has been debated, and the judiciary has itself said, yes, we should be using international human rights law as we adjudicate, and so should legislators. So there's case law in different countries where that's come out of litigation. So it can act as a bridge. It can actually be more than a bridge. It can be kind of, the judiciary sometimes points its finger at legislators and says, this legislation and its application is contrary to international human rights law, and we are required to use international human rights law to interpret legislation and in the application of legislation. So I think there's a real richness there. The problem of only relying, and I know the question didn't suggest this, but we don't want to just rely on legislators and the judiciary. We don't want to over-rely on the judiciary, to say, because so few cases make it forward where this might be relevant in the right to housing situation. But, you know, at the lower levels of adjudication, like, because landlord-tenant stuff happens at the lowest level generally, it's tribunals normally, administrative tribunals. I would love to see adjudicators take seriously the right to housing and international human rights law. You don't often see it at that lowest level, right? Where you do see it in higher level courts, judges, but sometimes, I mean, I've had personal experience at a tribunal, more than one tribunal, where the adjudicator's like laughing at me as I'm introducing international human rights law and standards and asking them to consider it in the context of housing, right? So there's a lot of undoing that has to happen there, and education that has to happen at that very low level administrative tribunal place where so many very important hearings are happening, right? That's where eviction hearings are happening. I hope that answered the question.
Well, for me it did. I hope for Emma it did too. It's 5 o'clock in the Netherlands. That means that it's officially over, but we still have one question by Jane Ball. I don't know if you have still time, 5 more minutes maybe, to answer that question.
And I was late, so I'm here for another 5 minutes, yes.
Nice, great, thank you. Jane Ball, maybe you could open up your mic and ask the question.
I'm asking my favorite question, which is the how question. How are you going to do that? Because the whole balance of things is shifting, and the power of people to afford anything is shifting, and clearly evicting large populations is a bad idea. So I understand the need to specialise and to proselytise about the right to housing, but I'm afraid the position in England is that, you know, you can get practical things done, but you can't necessarily get the rights thing done, even though the one might reflect the other.
Yeah, thanks for that question, Jane. Oh, sorry, were you not finished?
No, that'll do fine. I could go on.
I think there's a lot of myths around the right to adequate housing under international human rights law, as if it's some airy-fairy thing, some ideal, something we talk about while drinking coffee and eating croissant in Geneva, and that it has no practical applicability. And that is just so wrong. I have been working with city governments and national level governments, well, for many years now, and certainly since I was rapporteur. And I try to encourage an understanding of international human rights law as something very concrete that can be implemented, and that is not the stick that most governments view human rights as a stick, like, you know, advocates are like beating them down with this human rights stick, and I like to say no, human rights are a carrot, because we all want to live in more equal societies, more peaceful societies. We want people to be happy, joyful even, and human rights, which have at its base, its fundamental equality, is what drives human rights. Human dignity is what drives human rights. So no, we have to use human rights, and we can use human rights to create the cities and societies we want to live in. And I do find that is resonating. And then I can go even further and show governments how they can do the right to housing, what that looks like. And that's why I wrote the reports I wrote as rapporteur with that in mind, so that states have everything that they need to start legislating and drafting and creating policy and programs that are right to housing compliant. And so now I really feel I helped, and my predecessors and hopefully my successor my predecessor certainly also contributed to that. So I feel now states and governments have, and the judiciary, etc., have everything they need to on the how, Jane. And of course, it's always high level at the international level, because anything we write has to be applicable in 198 countries or whatever. So it's, you know, it has to be kind of high level in that way. But I really believe that my body of work and my predecessors provides the how. I think now things are so unequal and people are suffering so much, especially with the cost of living right now, and the cost of housing in particular within the cost of living, and energy bills being a huge part of that. That's part of the right to housing, the being able to afford to heat your home and cool your home. I think that city governments in particular, but national governments too, are casting about for how do we meet the needs of our populations, and I think they're going to come to human rights quite naturally. I'm an optimist.
Sarah, Vic had also a question, and it sort of relates to this topic, and it relates also to a few topics a while ago. Sarah, could you comment on your question that you posted in the chat?
Thank you. Thanks. I really enjoyed your talk. Thank you very much. I found that comment that you made really interesting, that you said you don't believe in shelters. And that homeless people often don't want the homes that are offered. And I understand in a developed country that you can say, well, give them better housing. But in South Africa, where we've got a massive housing problem and homeless people don't want the housing offered, I find that very difficult, that comment. I was just wondering whether you think it applies to developing countries as well, and what we should do when homeless people don't want the housing that's offered. Thanks.
Yeah, I mean, it is more difficult in the developing country context. And of course, I am familiar with South Africa and many other places where homelessness is an acute problem, and informal settlements continue to grow. My sense is that the only way forward in many developing countries is to regularize informal settlements and improve them, upgrade them, and provide them with all the services that they need, proper roads, etc. Now, in some cases, informal settlements are located poorly, often on the outskirts, and this is true in South Africa, of course, on the outskirts of a city, not close to any services, etc. So that has to be looked at, and whether relocation is more appropriate to other lands. But I mean, none of this is easy, of course, and but we do know you can't force people to live in places and in conditions where they don't want to live. So we always use Mexico City as the example where the government decided, oh no, it'd be great to get everyone housed, and no one would disagree with that. Great. So what did they do? They built thousands and thousands of houses on the outskirts of Mexico City, where people living in informal settlements were expected to be relocated. Some people relocated there, spent a month or two there, and realized that we are in the middle of frickin' nowhere, and there's no services, and our jobs are back in city center because a lot of people were working in the informal economy, etc. And so what did they do? They didn't stay in those homes. They moved back to city center and continue to live in informality. So, I take your point, Sarah. But none of this is easy. But certainly, steps could be taken to not evict. It's very easy for governments not to evict informal settlements. All that takes is for the government to refrain from acting. And then from there, they can take proactive measures, positive steps to regularizing, providing a degree of legal security of tenure, as we discussed at the top of the hour, as well as providing services, ensuring that if it's poorly located, and I don't mean on toxic lands, I just mean that's a real problem, but if it's just outside of city center, ensuring there's access to transportation, that people have or access to employment opportunities and healthcare facilities and education where they are. So there's so much that can be done with what already exists is what I'm suggesting, rather than governments trying to create new realities for people without ever discussing with those people what they want. I do believe in people-led solutions. I think everywhere I've gone, I find people have incredible ideas, and that most people are pretty modest in those ideas. Most poor people are pretty modest. They're not looking for a castle. They're looking to be able to just live a normal life, and they have great ideas. So I don't know if that answers, Sarah. We could probably discuss and debate for hours on this one.
Many thanks, Leilani. I think that this is a good wrap-up of the talk. Thanks a lot. I really enjoyed your presentation. Over the past couple of talks, we discussed also a lot of domestic cases. So it's really nice to, over like a year and a half later, we could really sort of get everything together and talk about the role of international law and see that it is in some ways a lot different. As you already mentioned, in some countries, international law has more interpretative role, and in other countries like the Netherlands, it's way more and powerful role that it has. But still, you see that similar problems and similar questions arise. So it's interesting to talk about what role the international law should have. And I think maybe for a next talk or in the future, we could talk about what role legal research could have in this area or should have in this area. That would probably be a nice addition.
Yes, or the connection between legal research and social research.
Exactly. Yeah. Definitely. So thanks again, and thanks everyone who joined. And we hope to see you next month in the next EVICT talk. Bye-bye.
Thanks.
Bye, everyone.
Goodbye. Thank you.
Thank you very much.